This debate about whether or not the justices at the Supreme Court the number of justices at the Supreme Court should be capped, comes up every now and then. In fact, recently when the president nominated some 4 justices for the Supreme Court, questions were asked about why we need more justices at the Supreme Court. But what does the Constitution say? And making reference to what happens in the United States, can that also reflect in our local situation, especially because we derive the inspiration from the Constitution of the United States and the British as well? I have one person who lives the Constitution. She served both at the global and continental level and for the Republic of Ghana as Chief Justice. Sophia Akuffo is my guest. Thank you so much for agreeing to speak to us today.
My pleasure.
Before we get into the substantive question about capping of the number of judges at the Supreme Court, what is the role of the Supreme Court in our justice delivery system as a country?
The first one, which most people are aware of, is that it's the final court of appeal, which means that a case may start in the magistrate court and go through the ranks all the way through, and from the court of appeals, there's another opportunity for appeal, and that is to the Supreme Court. But beyond that, the Supreme Court also has what we call original jurisdiction. Original jurisdiction in the enforcement of the Constitution and the interpretation of the Constitution. The normal, ordinary human rights provisions of the Constitution, those can originate, if you want to enforce it, you can originate the enforcement of your right, your personal right in the High Court. But if you want to enforce it, not necessarily because you have been harmed, but you feel that something that is going on and is being allowed to go on is harmful to the general populace, you could actually bring it to the Supreme Court. And if that's the first time, it will be interpreted and enforced there. If it has already been interpreted before, then it becomes part of our general law. So then you enforce it, you start it in the High Court or even in the Circuit Court, if it depends.
So even though it's the final court of appeal, can the Supreme Court review its own decisions, as in rule the matter? But if I, as a person, feels that, look, I still have a case, I can still have the Supreme Court review its own decisions?
Yes, under the Constitution, the Supreme Court has the power to review its own decisions. But to bring an end to things, it defines the parameters within which it will exercise that jurisdiction. The review is not intended to be a second appeal in the Supreme Court. No. You have only one chance of appealing to the Supreme Court. But if you feel, if you think, or if you believe that there was a very important fact they seem to have completely missed, and because they missed it, injustice has been done to you, you can bring the application. But then they will look very critically at it. Or maybe a certain law was not applied and it ought to have been applied. Or you've come across a certain piece of evidence which all the time you didn't even know it even existed, and you had no idea at all. So review is not something that is granted very often. It's few and far between. Yes.
Can the review, if granted, lead to a change in the earlier ruling or judgment?
Oh yes, oh yes. After all, that's why the person wants the review. They want the decision to change, and if it is a justified review or a justified application, yes, it will change the decision.
What are the essential characteristics of the Supreme Court in fulfilling the role that you have just talked about?
It's the final court, or the essential characteristics for it to be able to do what it does. Yes, it has to be credible. It has to be effective. In fact, justice at any and every level has to be credible. It has to be effective. Credible in the sense that all things being equal, if you lost, you will feel yes, the facts didn't, or the law didn't favor you, and that's it. It shouldn't be that, and if you want to appeal, the appeal normally should be because you believe that your facts were not properly taken into account, or the law was not properly applied. So it's the facts and the law. If these two are handled properly, professionally, and as they are supposed to be, that's what we train as lawyers, and eventually you become a judge, and to be able to analyze facts and apply the law to it. And so appeals do not always, just because you've appealed doesn't mean you will win. Because sometimes the fact that you think the judge did not comprehend or did not take into account will be so minuscule that even if it is now taken into account, you still lose. So you can as an old judge once said, the court can be right and it can be wrong, and that's why there is a right of appeal. But there has to be also an end to litigation. That's why it's decided that this is the final court. So in Ghana, in terms of appeals at the Superior Court, you've got 2 bites at the cherry.
Right.
Yes.
I see.
And then the review is another kind of opportunity, but it's not an appeal, as I've said. Yes.
And at the apex courts, what we've seen over the period is the question about the impartiality or the independence of the
exactly
itself.
Exactly.
How in the discharge of their duties are they able to prove beyond reasonable doubt that there is independence and there's impartiality?
Who's proving? The judge?
Yes.
It's not the judge's job to prove that they are independent or impartial, but that is how you do the job. It's a quality. It is a sine qua non. It is assumed. It's one of those things that should be assumed, because how do you get credibility? How can you be a credible judge if it cannot be, your independence is questionable? But you see, judicial independence is both internal and external. Internal in the sense that you're not taking sides. You've read this one, you've read and listened to this party, and you've read and listened to that other party, you've listened to the witnesses, you've done your research, you've looked at all the applicable laws, and you put it together to come to a conclusion as to who is right and who's wrong, because we do have an adversarial mode of arriving at our judicial conclusions. So primarily, you're not there to mediate between the parties. You're just going to decide this one is in the right and this one is in the wrong. This one wins and this one does not win. And to mitigate that is why for almost about 20 years now, the judiciary or the administration of justice has been adjusted in such a way that at the trial stage, you're given an opportunity to have the matter mediated. So you win some, you lose some. You owe me 10 million cedis, but if you will, if you will pay me 8 million today, I'll just drop it because I have taken other things into account. But that's at the trial stage. But strictly speaking, throughout litigation, all the way, the parties can always agree to mediate their dispute and settle it and announce their settlement to the court. In fact, there was once a case in the Supreme Court where we were ready with our judgment, and then the lawyer for one of the parties said he has been discussing the matter with the other lawyer, and they would like to be given the opportunity to settle it amicably. So we gave them, I think, 3 or 4 months, and they came back, and we were very happy with the outcome they had come with, because it was as it should be. It had to do with a community, and so they could now continue to be a community rather than disputants, and one lost and one won and one laughed at the other, and it leads to more fighting. Yes.
You see, every time this issue about and I asked about the independence and impartiality of the Supreme Court for specific reasons, because not too long ago, with certain high-profile cases, that question always comes up as to how impartial or independent the judiciary is. If all the justices at the Supreme Court are giving the liberty of having their own opinion based on their own reading of a particular case, and so they can dissent and not necessarily rule all 9 judges in a particular direction, 7-0, 9-0. The likes of the National Security Minister and others, governance experts, think that it sends a certain signal, raises questions about the independence of the Supreme Court justices.
You see, unfortunately, that is perception. That's not necessarily what is or what was. Because just because 9 people, there were 9 judges, right? Yeah, just because 9 people came to the same conclusion does not make it a doubtful outcome. If it's a bad case, it's a bad case. If it's a good case, it is a good case. There are some cases that are so awful and baseless, and all the judges can agree. Sometimes they can agree for different reasons, but they will all arrive at the same conclusion. Other times, the matter speaks so much for itself that after having judgment conference, because that's part of the process, the behind the scenes process, the panel meets, and each one then talks about what they think should be the outcome and for what reasons, and so on and so forth. And sometimes it is so glaringly good or glaringly bad that they'll decide, okay, one person should write the opinion, but each one of them can write their opinion. And we've had cases whereby all 9 will all write their opinion, but for different reasons, or they may agree on certain aspects, but their reasoning for arriving at a certain aspect of the issues may be different, but equally valid. That is also judicial independence, to agree with your colleagues as to how you arrive at Adan, or whether you will go through Somanya, or you would prefer to go through Akuffo and wander around and round and round, or go directly. That's everybody's right. So the fact that there have been a series of cases, and the Supreme Court has been ad idem, the judges have agreed with each other. Yeah, it happens all the time. There's nothing wrong with it.
Because you talked about perception, to what extent does that take some level of consideration in the Supreme Court dealing, so that people's experiences with the Supreme Court, or any, not just the Supreme Court, but the judiciary, is what is captured in surveys conducted by the likes of IEA, capturing people's experiences with the different arms of government, and in this case, the judiciary. So would you disregard the experiences of the people that captured in these surveys as against what your experiences are about?
You see, now I'm a former judge. I could be lecturing, I could be training, I could be actually doing surveys and so on and so forth. But when we come to what a judge sitting on that bench over that case is expected to do, they are so expected to apply the law to the facts as they have understood the facts. And you see, that's why they would, even at the Supreme Court and at the Court of Appeals, they also do, because when it's a multi-judge panel, you always do meet to discuss, because sometimes you've got this angle but you didn't quite catch that angle, and you get a more holistic picture, because the group dynamics works positively when you do that. And but to arrive at your conclusion, you can't say, fellows, in the last case when we did this and that and we all agreed, the people were upset, so this one, let's let it go this way. Or, okay, two of you disagree and the rest agree. No, that cannot be. That is not how it's supposed to be. Now, that is why, you see, of the people who are interviewed or surveyed, I would like to know how many of them bothered to read the judgment. It's not therefore I will grant or therefore I refuse. That is the conclusion. How was it arrived at? It's the reasoning, the judicial reasoning in arriving at the decision. That is also crucial. Yes, it can run into 30 pages. I've seen, well, not in Ghana, but in other panels, courts I've sat on, somebody's opinion, one opinion, being over 100 pages. Yeah. Did you read it? Before you would say you agree or you don't agree. You have to read it. You must.
What constitutes the quality of justice? And this is something I know you've been very passionate about. I followed your presentations at The Hague. You still hammer on quality justice. What's the details of that?
Quality justice, in a nutshell, would be characterized by, well, as I mentioned, credibility and effectiveness. But credibility in itself would be fed by how knowledgeable the judge is. You know, that one you would call it competence, how competent the judge is. That's very important. Competent, firstly, there's a basic competence, know your law. Yes, it doesn't, these days we all agree, doesn't all reside in the bosom of the judge. That's why certainly throughout the Commonwealth, continuing judicial education is harped on all the time, and they go back to the classroom and be taught about trends and what is happening in other jurisdictions, and new enactments, complicated enactments. You take them through provision by provision and so on and so forth. So it's competence. It is also independence. Independence is as I said, it's sine qua non. You cannot have justice. The word justice itself is not even just a common word. It's even I would say it's a religious word. It's a biblical word. Yes, it is just. It is as it should be. Yes. So that's why independence and integrity. You cannot be independent and lack integrity. And if you lack integrity, you cannot be independent. So that they go together. And then efficiency. You know, sometimes the delays in the whole thing from the commencement and through on and on and on and on and on and on, that can give an impression that they're up to no good, or I won, but by that time the money was worth nothing to me, therefore I did not get justice. A litigant can say that. Yes. So efficiency is important. Efficiency is also partly personal to the judge, and to a very large extent also your workspace. How efficient are your? These days it's not your pen anymore. It's your IT, your connectiveness and all that. And that's why things like e-justice and so on become very important. That's why, once again, I come back to training, judicial education, and even also the training of the staff. You can be a highly judicially trained and educated judge, but if your support staff lack in one skill or the other, that can be a problem. So competence is also part of that. Yes, and then it's when you're looking at all those things coming together, that's when public perception is also important, because if you've delivered in an independent and impartial way with integrity, if you've applied all your knowledge to what you're doing, you've applied all the modern technology and all that to arrive at your decision, and it comes to, let's say, execution of the judgment, and nothing happens. The person won, but they might as well have lost, because now it's a big hassle to go to get your land back or your house back, or get the person to pay your money back to you. Then you're blaming the judge. That judge gave me a useless judgment. No, the judge gave you a good judgment. It is the execution that failed you. Yes. And execution of judgments are both part of it. There's the bailiff service, and which also needs, I have to admit, still needs a lot of work to be done, a lot of inputs to be put in there to make them efficient. And then part of the execution, you need the police service to help you do the execution, because it's really an executive act, to execute a judgment. And for me, perception and its result on effectiveness is important, primarily because when your outcomes, in other words, as I said, the judge wrote a perfect judgment and gave you a good decision. It's not been appealed against and all that, but you're not getting the fruit of your victory because of execution being, the person is successfully maneuvering you all over the place. See, those are the things that lead to self-help.
Resorting to the use of either land guards to get a land back.
Yes. Yes.
Forms. You talked about the timing or how long it takes, for instance, for cases to travel all the way to the end before the judgment is even given. How important is timely justice, taking into consideration the saying that, yes, if justice delayed is justice denied, but when justice is hurried as well,
justice is buried. I'm glad you know that second part.
How do you balance in between the two?
You balance it through effective case management. All these are systems and methodologies which are now in place to help right from the lower court all the way. Even the rules of court procedure are part of case management. If you sue somebody, this is how you do it, and when you have filed it, after this period, within this period, this is what's supposed to happen. After this period, this is what's supposed to happen. Those are all the laid down procedural processes. Many times the procedure is there, but it's not being followed. Maybe the person started the case, and yet the writ has not been served yet. So you're waiting and waiting and waiting. Every time you go to the court, oh, we haven't been able to serve the writ. There are processes whereby if you've tried a certain number of times to serve and it has not been, the service has not taken place, the plaintiff can trigger a certain process for substituted service. That is there. But if you don't trigger it, then I don't know what's happened to your writ, but your writ has not been served, and you're just sitting there and you're lamenting, these court people, they are all thieves. And the magistrate, the thing has not even reached the magistrate yet. And the magistrate is already being insulted. Yes. And so on and so forth. So if people would take an interest in the process, what ought to be, if people knew what ought to be, then they could really be very critical about what is being done. Because I was always sometimes very concerned about how long it will take, let's say, it will take a litigant to take the next step, which they could have taken months ago, because there has been the time lapse, the statutory time lapse, whereby you can apply for default judgment, you can apply for the case to be thrown out, you can apply for this, you can apply for that, and you're just sitting there and nothing is happening. That is not the process's fault. It's you're not a vigilant. Equity aids the vigilant, not the indolent. Yes. But all things being equal, it is possible for a judge, once the case has landed in that judge's court, to so manage the process that The judge will even be able to tell when hearing will end and when judgment can be delivered. There are some judges at the High Court, for example, who they've perfected their case management systems, because once it's your case, the case is before you. You're the one who you time it, and the lawyers who want to play their tricks, they know the judges to avoid, because they know this adjournment they will not grant it. They will not countenance unnecessary delays. And one judge in particular, she would write out a timetable for the case, and then have it served on all the parties, and they've agreed on this date, on that date. You will take your witnesses, you will do this. And these days there's a witness statement. So every person producing a witness comes up, brings the witness statement, which is sworn. It's like an affidavit. So it's only the cross-examination that's done in court. Yes.
Thank you. Yes.
We wait for 2 minutes and
What's happening?
Intervals. So after 30 minutes, we go for a short break so that we can cut them.
Okay, no, so I think we still have. We talk about the quality of justice and so on and so forth, but in the quest of assuring justice, do numbers matter, as in the number of justices?
Yes. First, well, it does. Yes, because there's a minimum that's been set by the Constitution, and you cannot fall below that minimum. In an Article 128, let me read it to you. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices. So the Supreme Court is a Supreme Court of a minimum of 10 justices of the Supreme plus the 9. Yes.
Is there a cap for the maximum number of justices?
No. So that's where the number becomes debatable. But as to whether number matters, yes, 10, that matters. That number matters because the Constitution says so. If you fall below that, you don't have a Supreme Court. Yes. So, but as to whether as to what should be the optimal number, it's a number of factors. It's not as these, there's a certain modern Ghanaian tree expression, and yet it's not as simple as that. Because what is the load? What's the demand? What's the workload? What's the, coming up with the workload, what's the backlog? Is there any backlog? What's the frequency with which people are now? I cannot tell. In my time, that because times change. People are litigious at certain times, and other times they are not. And so you have to be constantly checking your numbers. For the longest time, I think the Supreme Court sort of ranged between, the highest I ever saw it whilst I was on the bench was 15 for a very short period. But on average, it's been between 11 and 13. Always an odd number helps because the Chief Justice is not always available to sit because the Chief Justice is also doing administrative work. Yes. So you need to know what is your optimal number for efficiently disposing of the cases that are ripe for hearing. That is also an expression that because for a judge, there's a certain period where you have nothing to say, you have nothing to do with what is going on, and then it lands on, it's ripe for hearing. In other words, everything has been done, and it can now be listed and distributed, and it's being heard. And normally, really, I don't know about now, but on average, during my time, the longest that a case will remain in judicial hands would be about maximum 6 months. But then that may be because there were some vacations and so on and so forth. Because usually, once it comes to you, you hear it once, and then you adjourn for judgment. But sometimes there might be some other things that you want them to come back and address you on before you finish. But 6 months, that's fine. But some cases would languish in the registry because lawyers have not been filing what they are supposed to file, and or somebody dies and they have to be substituted, and so on and so forth. But when the case is in the hands of the judge, and sometimes because of numbers, we're talking about numbers, because minimum number to sit on a case in the Supreme Court is 5, except for certain rare situations, and normally some kind of simple applications that one judge can sit on. Yes, but to hear an appeal, for example, minimum of 5. To hear a constitutional case, the practice has been minimum of 7. And in case there's a review, then you have your reserve 2, or plus the Chief Justice if need be. Yes.
And the number of, or the adequacy of justices impact on efficiency?
Oh, I think so. Because you don't really, every overworked machine gets tired. Yeah. So it can sometimes even delay. And sometimes I remember as Chief Justice, when I would be empaneling, I tried to have a certain rotation so that the same judge does not, let's say for 2-3 weeks running, have a hearing. Because every hearing you have, most likely you're also going to be writing a judgment or a ruling. And rulings and judgments, to me, they're about the same. Yes. And it requires the same attention. So you need to give them sufficient time to read the files you're sending to them, and to mull over the extra things they heard at the hearing, and then prepare for the writing of the judgment. And sometimes when you have a very complicated case, you're trying to sleep. You've decided, okay, I've read it. I think I've understood it. Now I'm off to bed. And then you think you're dripping off, then some ideas. You grab your pen, you write a note in case you forget by the morning. And so the case is with you till, it's like pregnancy. The case is with you till you deliver, till it is delivered, yes. And if if it's going to be a unanimous judgment and it's been decided that, okay, so then you, so and so, you write, that is there's another burden, because you're going to draft it, you're going to circulate it. This one is coming in with, check this part. I don't agree with this argumentation. And sometimes it can be decided, okay, if you don't agree with it, you can write your additional opinion. But it's the same conclusion, but additional opinion, as we've already said, as to all the permutations.
You see, I asked earlier about whether there's a capping or there's a maximum number of justices that can be appointed to the Supreme Court. There's always a reference to the United States where 9 judges by legislation are appointed to the Supreme Court. Should the numbers be fixed, in your view, having served as Chief Justice?
I don't think so. It's not necessarily, you see, because I would always come to the question, in what way will numbers assure quality justice? In what way will numbers ensure timely justice? In what way will numbers necessarily impact on efficiency and so on and so forth? So, as I have already said, and that is why I've always found it difficult to completely agree with a capping. I've always felt that 15 is a perfect number. Why? Because 15 gives you straight away 3 possible panels, so that you can be doing your normal cases. But that also will depend on the caseload in the registry, the demand. How many cases are otherwise ripe for hearing, but everybody is exhausted? Yes. And 15 would be perfect. 15 could also be that there can be 2 courts even sitting simultaneously to do cases. But 15 may not be what is required if most of the cases coming on are constitutional cases where you need 7 to sit on the case. Yes. So it's all a question of the demand. So and please, the U.S. Supreme Court sifts, they filter. And to a large extent, one can say the formula is arcane and known to them. But primarily it is if the matter raises a novel issue, or things have changed so much since an old precedent, and now the court should take a second look, like Roe and Wade. I never thought that Roe v. Wade would be thrown out, but they've done it, okay, because they felt that the times have changed, okay. In Ghana, appeals alone, once somebody has filed an appeal and lost in the Court of Appeal and feels like, and that's how I will put it, because some of the appeals that land in the Supreme Court are based on feelings, not on law and facts. Yes, appealing, they can. And if the case started in the lower court, they will need the leave of the Court of Appeal. So but if the Court of Appeal refuses the leave, they can apply for special leave in the Supreme Court. And in as much as the Supreme Court has tried to define the scope of the of what entitles somebody to special leave, people will still try it for luck, and therefore their application will have to be heard. So we're talking about judge time and sitting time and hearing time. That also affects the numbers, the requirements of numbers, you know. And then there's also review, which is also, strictly speaking, review is as of right, but as to whether it will be granted or not, it is within certain limited parameters. But nothing stops the person from trying it on for size. And sometimes, and to a large extent, a lot of applications for review are nothing more than a second, an attempt to bite another piece from the cherry of appeal. Yes.
I asked this question bearing in mind the Constitutional Review Commission's recommendations in its white paper that the justice should be capped to 15. Right? What's your view on that?
If it were possible to cap it by legislation, so that it will be purely a responsive capping, as strictly speaking the US 9 is. It is by legislation. In Canada, it's by legislation. In India, it's by legislation. Same in the Republic of, the Republic of Ireland. Yeah, that will be, that will not be too bad. But to the extent that, and then maybe it's debatable, maybe it's something that can be attempted and then somebody can challenge it and then a decision can be made on it. But I'm of the view that, and these days my views don't matter because they're not any, unless the matter is sub judice. Okay. And my view is that the Constitution chose to set a minimum. It did not set a maximum. Therefore, the Constitution chose to set upward numbers at large. Yes. So if you want to now cap it, then you have to cap it at least by a constitutional amendment, which would say that, which will empower Parliament from time to time as the demands as public demand or the demands of the court services dictate, to set a maximum. But until that will have to be a constitutional permit before, in my view, Parliament can decide that we have set this maximum 15 for the Supreme Court, even if it says it can be revised from time to time. That leverage to swing this way and that way is not available at the moment. That's why I think it has not been done. It should have been done long time ago. Yes.
If the argument you're making is anything to go by, it's something that may be worth considering if it's going to, for instance, enable the creation of special chambers and so on and so forth. But should it be by constitutional amendment or by legislation? Quick one.
Which one? The creation of the capping?
Yes.
Oh, I'm saying that it cannot be.
Conventional practice is enough.
I think that in the best of all possible worlds, the conventional practice is enough. Of course, people are always afraid that there could be some really evil-minded executive that would decide that I'm going to do my own thing and I'm going to I'm going to appoint 30 Supreme Court judges. I think that would be very difficult. You see, because the process, imperfect though it is, the president just doesn't get up and say, I've nominated 20 people. No. The nominations to the Supreme Court originate from where? From the Judicial Council, which is also a different body chaired by the Chief Justice. So such a president will need the buy-in of the Chief Justice who is chairing, and the Judicial Council, which is made up of, yes, in my view, there are too many people on the Judicial Council who are nominated by the president. I've always felt that's an overkill. But on the whole, most of the membership is ex officio. The Judge Advocate General, the head of legal police, the president, the national president of the bar, and then representatives from the regional bars, the dean of the University of Ghana School of Law, and then so that is and then judges from, there will be a Supreme Court judge, there will be a High Court judge, a Court of Appeals judge, and so on and so forth. So all these people, they're not just going to sit there and a whole bunch of yahoos appointed as justices of the Supreme Court. Not even judges or magistrates, let alone justices of the Supreme
but
Court.
You agree that
So conventional.
But the conventional practice has its own imperfection.
Yes, but other than if we're prepared to go through a constitutional amendment, that provision will have to be by referendum, because it will be tinkering with entrenched provisions.
If the argument you're making is anything to go by, it's something that may be worth considering if it's going to, for instance, enable the creating of special chambers and so on and so forth. But should it be by constitutional amendment or by legislation? Quick one.
Which one? The creation of the capping? Yes. Oh, I'm saying that it cannot be.
Conventional practice is enough.
I think that in the best of all possible worlds, the conventional practice is enough. Of course, people are always afraid that there could be some really, evil-minded executive that would decide that I'm going to do my own thing and I'm going to I'm going to appoint 30 Supreme Court judges. I think that would be very difficult. You see, because the process, imperfect though it is, the president just doesn't get up and say, I've nominated 20 people. No. The nominations to the Supreme Court originate from where? From the Judicial Council, which is also a different body chaired by the Chief Justice. So such a president will need the buy-in of the Chief Justice who is chairing, and the Judicial Council, which is made up of, yes, in my view, there are too many people on the Judicial Council who are nominated by the president. I've always felt that's an overkill. But on the whole, most of the membership is ex officio. The Judge Advocate General, the head of legal, police, the president, the national president of the bar, and then representatives from the regional bars, the dean of the University of Ghana School of Law, and then so that is how, and then judges from, there will be a Supreme Court judge, there will be a High Court judge, a Court of Appeals judge, and so on and so forth. So all these people, they're not just going to sit there and a whole bunch of yahoos appointed as justices of the Supreme Court. Not even judges or magistrates, let alone justices of the Supreme Court.
You agree that
So conventional.
But the conventional practice has its own imperfection.
Yes, but other than if we're prepared to go through a constitutional amendment, that provision will have to be by referendum, because it will be tinkering with entrenched provisions. Yes.
Finally, and this is really important, I mean, after all is said and done, should we regard this call for the capping of the justice to the Supreme Court as a demand-driven one, as the optimal number is best left to demonstrable need?
Definitely. And demonstrable need would be all the way from demographics and to scientific study of the trend in petitions and applications and various forms of seizing the court for cases, how many appeals, and so on and so forth. That is what will drive it, because I can also envisage that you cap at, let's say, 27, and even have 2 or 3 different chambers. And one chamber, somebody is busier than the other person. Demand. Or you decide to even cap at 15, but for the next 5 years, I can imagine that for the next 5 years, you will be using all the 15 almost simultaneously. Okay. But after a time, you may find that the steam is out, and on the whole, you don't get so much or so many of appeals anymore. I remember in terms of types of cases, because as I said, the Supreme Court has, if you go by subject matter and areas, the Supreme Court's jurisdiction covers about 12 different areas. So chieftaincy appeals. Oh, we used to have so many chieftaincy appeals, this thick and all that. By the time, I think when I was Chief Justice, I don't recall more than 4 or 5 during that period. Yes, and even before that, I can't really remember any chieftaincy appeal that came. Why? Because the trend has changed, and enough decisions have been given for you to advise you as to the chances of your appeal succeeding. Yes, and another trend, I suppose, would be, let's say, human rights cases, and so on and so forth. So it's a these are times, trends, and therefore demand. Yes. So how are you going to fix the top side? And then you find that, oh, you don't even, this top side is ridiculous. Yes. But then in some places, because the Supreme Court sometimes sits in different places and can sit in those different places at the same time. Oh, they've got lots of judges, over 30. I in my notes, I was looking at some of these. Yeah, but there's the U.S. Yeah, I have here. The U.S. Supreme Court takes only about 5% of the cases that are filed because it filters, but we can't filter. Yes. So if suddenly everybody is asking for review, everybody is appealing, there are more chieftaincy appeals coming again, and every criminal is also appealing. Criminal appeal is very minimal, believe it or not, because maybe it's not lucrative for the lawyers, or because the people can't afford it, or whatever. But if something changes, you don't know. So it can be high, it can be low. Just don't fall below your 11. Because the 11 works well. Because there can be recusals. There can be ill health. There can be, I recall that when I was on the Supreme Court and at the same time also a judge at the African Court, I was doing cases, but the Chief Justice reduced my load. Right. So that I did not keep, I wasn't overloaded by the multi, yes. Right, exactly, and so on. And I mean, because right now there's a judge who's, I think, on the ICC. Yes. We don't know how much demand that's going to make on his time, whether he's even working here or there. Still, there's demand on time, on focus, and everything. So there can be so many reasons why even this conventional 11, sometimes suddenly you find that those that are actually available are fewer because of ill health and so many things, because it's not young men and women who go to the Supreme Court.
Justice Sophia Akuffo, thank you so much for this, and I just hope that this detailed analysis and explanation would put to rest some of the questions that people raise about whether or not the number of justices at the Supreme Court should be capped, or we should go by the constitutional provision as it stands now. I'm sure the debates and the jury is out there on this matter. Mm-hmm. Thank you so much for your time.
You're welcome.